forget and admit these folks. But we ended up going ahead and moving to online only with that because that's who was participating.
Because they can't get out hardly.
In some cases, yes. And what was fascinating was that we also ended up having some folks who were aware of us and wanted our assistance and were operating out of state. They had moved from here, which is how they had come to know us, to whether it was hometown, returning to a hometown in another state, or whether it was just where mom or dad or sibling happened to live as the years and relocation may have occurred. So it's fascinating to watch how we go ahead. Let's get you all admitted. How we go ahead and find ourselves just adjusting to a new reality. And online learning is definitely a huge part of that. So, and I see that it looks like everybody who wanted to be admitted at this point is admitted. So I'm going to say a formal hello and good morning to each of you. We have a couple of people here in our conference room at the Hope and Healing Center and Institute, and we have some of you joining us live. And I'm going to say a hello to those of you who registered and are watching this recording at your leisure, hopefully with copies of the slides nearby in case you'd like to refer to those throughout the presentation. My name is Seth Stander, and I know you can only see the back of my head based on this view, so I'll turn a little so maybe you can see me waving over here. And I am the community aging specialist for that part of the Hope and Healing Center and Institute known as CARES, which is an acronym that really focuses in on our operating areas: caregiving, aging, resilience, ethics, and spirituality. Our director of CARES is Dr. Peggy Dettermeyer, and today we are in the second of our 4 sessions for this season, the spring season of Aging with Grace. We're going to be focusing on legal considerations this morning, and in upcoming weeks, we're going to address understanding living options and paying for aging. As I alluded to before, these are all being recorded. Every registrant for our sessions is going to get a recording, copy of the slide deck that's being used for each session. All of this is part, and Beverly, the presentation, if you look on our website, these are all going to migrate over there as well. So you'll be able to see it under the resource tabs for hhci.org. So no worries there, and you're very welcome. Our mission here, ultimately, through CARES, in concert with our clinical services, our Gateway to Hope educational programming, our Hope Line, a warm line that runs from 5 to 8 p.m. every day of the week for folks who just need a half an hour to talk to somebody about their day, but are not in true crisis, thank goodness. We are all here to go ahead and to focus on the needs of those who are aging and those who are caregiving. We also want to go ahead and focus not just on the hopes and challenges of aging, but we are here through CARES, our division, to focus on bioethics, navigating the journey of grief as well, because whether it is grief through the loss of a loved one's life, whether it is grief due to unanticipated or even anticipated changes in life status, we want to be able to go ahead and support you through the online and in-person support groups we offer on a monthly basis, and through any of the pieces contained within our acronym through individual consultation. All of this is thankfully available to participants free of charge because we have an amazing philanthropic division and some incredibly generous lay leaders and underwriters in the community. So with all of that, I'm going to go ahead and I am going to share my screen so you can see today's slides and get ourselves started. Let's minimize there. And so hopefully everybody is seeing the front page here, legal considerations. And I'm going to start out because we are talking about legal issues, just as we would talk about disclaimers for medical advice. This is an overview of legal estate options in Texas. So we very much want you to consult with an estate attorney for specifics related to your own issues and your own locale. You may be located here in Texas. You may be located in another state where different rules may apply. These are general principles that we want to go ahead and emphasize to you, not just in today's session, but throughout our series. So first things first, let's start with the question, do you have a will or trust? And if you're uncertain as to what wills and trusts are, good news, you're in the right session. We're going to go ahead and talk more about defining these in ways that hopefully everyone will understand and embrace. And I'll deliver my bias to you right now. Everyone should be engaged in creating and or revising / updating wills. And if you happen to have trusts, to be updating, revising those as well. So my question was, do you have them? Yes, terrific. If you don't, and take this next piece tongue in cheek, no worries. The state of Texas has written one for you, which is why I put in parentheses, yay, because ultimately there is a whole section of the Texas Estates Code, just as there are in other states around the United States, that lay out how your property will be distributed if you die intestate. Intestate is just the legal term with lacking a will. So, are you ready for charts? This is actually easier than it looks, especially as you go ahead and consider what the state of Texas does for those who die intestate, that is, again, lacking a will. If you only have a surviving spouse, no problem, spouse gets everything. If you only have surviving children, children get everything. If you only have surviving parents, everything goes to them. Surviving siblings, everything goes to them. Where it begins to go ahead and go out of the easy, I won't say easy distribution, because an intestate distribution of assets does take time and involves a higher degree of court action than if you're going in with a prepared will and someone serving as executor of that estate that you have left and going ahead and executing the will with the cooperation of the court. So, for example, if you die intestate without a will, you have a spouse, and there are children of that spouse. The spouse is going to go ahead and receive community property. Several states around the United States are what are known as community property states. So everything that is brought in from the relationship onward is divisible in case of divorce, and certainly the distribution follows the community property rule upon death. That includes 1/3 of separate personal property and the right to use real estate, which is a fancy way essentially of saying you get to live in the house in which you and your spouse had been living. And in terms of your ownership of that property, the spouse is entitled to 1/3 of the personal property that their loved one has left behind. The community property remains the spouse's. The children are entitled to everything else. Now, how you define separate personal property gets into the issue of family dynamics. While I love Bowen family systems theory and could talk about it for hours, suffice to say, there may be ongoing familial issues that make the determination and distribution of personal property not as easy as it looks on a chart. So that's where ultimately a will may prove useful to go ahead and to specify what goes to which loved one after you die. Gets even more interesting if you consider whether you have a surviving spouse and children who are not children of that spouse. So everyone is still entitled to something, but as you can see, the distribution becomes even more complex. Half of the community property, as opposed to the full community property, a third of the separate personal property, the right to use the real estate. And then you can see the other half of the community property plus everything else, whatever that is, as far as family negotiations are concerned, working in concert with the courts, is distributed to the remaining family members. Here's more of that chart. You can see if you die and are survived by a spouse and by a parent or parents, the spouse will go ahead and get all community property and separate personal property, and they'll get ownership of half of the separate real estate because the parents in an intestate distribution in Texas are entitled to everything else. One parent and siblings, no spouse. Half of separate property goes to the parents. The siblings share the remaining half of the separate property that you left behind. Spouse and siblings are left behind. And you can see the distribution here. All community and separate property goes to the spouse. Half of the separate real estate goes to the spouse, and everything else goes to the siblings. Now, again, this isn't necessarily a terrible situation for every family, but what's happened here is without creating a will, without establishing a trust, without the legal advice and guidelines that you wish to leave behind, the state has to make its best determination of what is fair. And what is fair for one family may seem grossly unfair for another. So why not go ahead and take more control of the process before a crisis occurs and your wishes aren't necessarily able to be preserved for posterity? So let's talk about and focus in a little bit more in depth of the purpose of a will. As I have been alluding to, distributing your property to your chosen recipients, people or organizations. So of course, we're talking about a spouse, we're talking about children, we're talking about other relatives, but now, unlike an intestate distribution, if you have non-relatives, the family you choose, in other words, bonds of deep friendship or deep respect in the community, and you want to make sure that someone is listed in your will as deserving of a particular part of your property or possessions, this is an opportunity to go ahead and to make that choice clearly understood. Charitable organizations, perhaps your strength of connection with a community of faith, a nonprofit, with any other type of educational organization, you name it, has been so strong that you want to make sure that you continue to support them with your means after you no longer have any earthly need for them. In your will, especially if your children are not yet of legal age, guardianship for those children is determined. If you, for example, have any questions whatsoever about who will carry on to the best of their ability, not only maintaining the best quality of care for your minor children, but also making sure that the values you wish them to learn are upheld, here's the place to go ahead and to introduce that. An example. My wife and I, of course, when we created our wills and advance directives for after the birth of our daughter, we wanted to make sure that it was clearly understood that we did not, if God forbid, both of us died in a tragic blimp accident, want to go ahead and burden either my mother, still living at the time, or my wife's parents, her mother still living, her father still living at the time, with the responsibility of raising a grandchild and mourning a child simultaneously. We already understood on my side of the family that we really didn't want any of my siblings to go ahead and to take on that guardianship role, because we were uncertain as to whether or not the values that we felt were most important to communicate, not that they wouldn't do their best, but that their efforts would be successful, was a serious question for us. And my wife unfortunately no longer had a living sibling, so we ultimately turned to dear friends in the community who we understood would not only take good physical and emotional care, but also psychosocial and spiritual care of our daughter, if God forbid the need arose. So, long-winded way of saying it's not just about you. It's about making sure that your legacy and the values that you wish to perpetuate for the emerging generation of adulthood, and preparing that emerging generation of adulthood to live their best possible life, needs to be taken into consideration. And a great place to enshrine that and update it as needed is in a will. If you are fortunate enough to be a multimillionaire, first and foremost, please talk to our philanthropic department and support our activities. But beyond that, congratulations, and prepare for estate taxes. If your estate is over, and I did update these for 2023 numbers, so for those who may have seen recordings of previous, which include previous slides on these subjects, you're going to see some tweaks. I always like to keep us as up to date as possible. 12.06 million is for an individual, the threshold before estate taxes kick in, and who knows what will happen as the tax laws continue to evolve. And that's just simply doubled for married couples. If you don't fall into that category, I'm sorry, I don't either. But in the end, it's something to keep in mind in order to preserve as much of your estate if your goal is the successful transmission of multi-generational wealth. And the other piece I mentioned earlier and state specifically here, we want to make sure that an executor or executrix that you choose and you trust to manage your estate is clearly named. Obviously, this person has to be fully informed that they are going to serve in that role. And when the time is right, they will go ahead and take a complete tally of your assets and whatever needs to go through, and we'll describe the probate process in just a moment, whatever needs to go through probate and what otherwise can be distributed through direct delivery to beneficiaries who are stated in various items of worth that you own, they're going to make sure that that happens successfully. The requirements for a will. Now, remember that some of these are legal terms of art, which with a spouse as a lawyer, I understand a little bit better than those who may not have spouses for lawyers or be lawyers themselves. Let's do our best to decode these. Legal capacity. We actually talked about this in our first session when we were talking about healthcare rights and responsibilities. And legal capacity, as I defined then and redefine now, is to occupy a particular status or relationship with another. For example, marriage, parenthood. You have a legal status as an adult child of a parent. who may be in need of a decision maker if they're unable to go ahead and make such decisions on their own at a certain point in their life. To engage in a particular undertaking or transaction. We talked a little bit last session about advanced directives that include such things as a medical power of attorney and a durable power of attorney, documents that allow for someone to, the best of their ability, to follow your wishes when it comes to quality and quantity of life issues on the medical side, but also when it comes to handling your financial affairs and understanding what that means and how to go about it successfully so that your bills are paid, you maintain ownership of your property and possessions, your taxes are taken care of. These are ultimately what we talk about in terms of legal capacity. It's not just are you fully alert and oriented? It is, are you able to go ahead and to perform the tasks that are put in front of you? So when we talk about orientation and alertness, let's talk about testamentary capacity. That's a piece we didn't talk about in our first session. And that is the legal and or mental ability to make and or alter a valid will. Couple that with what is called testamentary intent. Why are you writing a will? Well, because you want control over the process of the disposition of your property after you have died, as it says here, in contemplation of death. So how does a will become legally recognized? If you have gone ahead and demonstrated legal capacity, testamentary intent, then ultimately you can have, as you see, 3 different types of categories. These are not the only ones, but when we talk about the formalities of creating a will, these are amongst the most common. An attested will, in writing, signed by you or another person at your direction and in your presence. Sometimes people have physical limitations for signing, but they are fully cognizant of what they want created and signed. So that's why that's in there. And attested in your presence by at least 2 credible witnesses over the age of 14, and this is important, who won't benefit from your will. In other words, we need people who are who will completely avoid conflict of interest. A self-proving affidavit, which, by the way, any lawyer worth their salt, as you are talking about putting together your will, durable and medical powers of attorney, your various advanced directives, and so forth, they are going to make sure that this is in there as well, because it is absolutely necessary in order to go ahead and to smooth your way through the probate process in the courts. A self-proving affidavit is a big deal because it affirms that the will was properly signed. It eliminates the need for witnesses, those witnesses in particular who witnessed the signing of the will in the first place, from going ahead and having to show up in court during a probate process. It is going to save you and the court a ton of time, and it is going to smooth out the process of fully probating your will and making sure the distributions occur in a timely fashion. Then there is the famous holographic will. Ultimately, and by the way, when I put in here in parentheses, including addenda, you can always go ahead and attach. Sometimes it is referred to as an addendum, addenda is plural, and you might also hear a codicil as the term that's used to go ahead and to add to an existing will. So whether it is a will that supersedes any other will that may have been created, signed, witnessed, or whether you've never created a will before and this is your first and only attempt, so long as it is written completely in your own handwriting and signed by you, a holographic will is legal. It still has to go through the probate process. You still have to indicate in there who you wish to have serve as your executor or executrix. But if you wish, at the end of your life, and you have the means, and you possess the legal and testamentary capacity and intent to do so, you can supersede anything else that's ever been created. Or if you just never decided you wanted to do it until you felt your time was near, so long as you start and finish it in your own hand, Gesundheit, that holographic will counts, and it supersedes anything that's come beforehand. It is legally binding. So I've used the word probate. What does it mean? And in particular, what does it mean here in the state of Texas? The good news is that it's going to mean essentially the same thing in other states as well. But again, I don't want to presume to speak for any nuances that other states may also use in their definition. Well, the first thing it's going to do is it's going to legally recognize that that person has died. And after death certificates have been produced, and we do recommend that you go ahead and you order at the beginning, as tough a time as it is when you're dealing with arranging for a loved one's interment or the disposition of their mortal remains, however you choose to do it. It is very important to make sure that you have multiple copies of the death certificate in order to go ahead and to make sure that as many accounts, agencies, real estate holdings, you name it, that need to know that that person has died, receive a death certificate so that they can go ahead and conclude the business of helping to wind up that part of that individual's estate. Now, that actually goes into the second topic here, which is to identify the estate, and the third topic, to gather all assets and pay out debts. The role of the executor and the executrix is to go ahead and to do both of those. They don't have to do it on their own, although they are in charge ultimately of the process and have the final say in submitting what is identified as the estate of the deceased and what all the assets are and what debts need to be settled. Now, what is not subject to probate, in other words, what does not, as you can see on the bottom line, become public record, because all probate records in Texas are public records. Ultimately, if you have insurance policies with named beneficiaries, that's going to get taken care of already because you've already signed that legally binding document. And the same thing applies because you've signed those legally binding documents with regards to named beneficiaries for your bank accounts, for your retirement accounts. Here's the one that ultimately you want to make sure about. And by the way, it's worth noting that this should be, where appropriate, specifically stated in this language when it comes to insurance policies, bank accounts, and retirement accounts. Property and assets held in, and here's the famous term, joint tenancy with rights of survivorship. So that is, as you can imagine, another legal term of art. And without it, your process of winding up an estate can be really difficult. So I strongly encourage you to make sure that if you have named beneficiaries already in the types of accounts that I've listed in this slide and described already, that the phrasing joint tenancy with rights of survivorship is explicitly in there. Sometimes accounts need an additional form in order to make that happen. I know this because my wife and I, after working with a true friend, the person who handles our retirement assets, as his company was being purchased and going through the transition process and going through their own internal audit, they wanted to make sure that every single account had joint tenancy with rights of survivorship documentation for every section of that account. And it turned out that we didn't quite have the language of art, even though we all believed that we had. So it took a simple form to be introduced and signed, and it was all taken care of. And now it's something we don't have to worry about in the future. It's worth double checking with the people you do business with in insurance and banking, in retirement accounts, you name it, to make sure that you have that phrasing in place. And if it's not a big deal at this stage to go ahead and to get that tweaked language taken care of with an additional form. Trust assets are the category I'm going to set aside for the next couple of slides, because we're going to talk about why, and we'll use, for example, the term revocable trust is another way of going ahead and protecting your privacy and streamlining the probate process by putting things into a revocable trust. They don't need to be accounted for in your will. I've mentioned before that independent administration through an executor or an executrix is a requirement. A bond for their services is not, although they are entitled to compensation, which they are free to accept or decline for their services. I believe the number is up to 5% of the estate. Obviously, if you've got people who are doing this as a labor of love, have that conversation with them and make sure at the very least that they are paying themselves back for any kind of expenses that for some reason they haven't taken out of your estate in order to settle. It's not their money. They're simply managing your money to settle the estate's debts and take care of any final costs, which includes, for example, funeral expenses. If for some reason there's a snafu and they need to front that money, please remind them to reimburse themselves. And then, because this is such a labor that it may take away from their own ability for a time to fully focus on their work, if that compromises their income in any way, remember they're entitled to a fee. Because it's our way of going ahead and saying thank you for providing this unique service to a loved one who has died. So let me go ahead and advance us forward and talk a little bit more about trusts. And I mentioned a revocable trust. In this case, let's specifically define it as a revocable living trust. Why would one want a revocable living trust? Well, hopefully I've given you some good reasons in these bullet lines. It enables you to use your assets during your lifetime to securely, and I could add in there, but it's already in the previous slide, privately transfer them to your beneficiaries upon your death, to name a trustee, could be you, could be your spouse, to manage during your lifetime. So in addition to having, say, for example, a durable power of attorney, you also are making sure that you streamline the process of allowing your spouse, if you become incapacitated, to continue to use your assets for your benefit as well as for the benefit of your spouse and your combined household. It can be changed whenever you wish. Now, there is an irrevocable trust category, which by its name cannot be changed. It's beyond the scope of today's conversation, but I encourage you to speak with an attorney to discuss the value of an irrevocable versus a revocable living trust. As I mentioned earlier, it avoids probate, which, as I described, is a matter of public record. And so these parts of your estate will not be a part of the public record if they are contained within the umbrella of a trust. It avoids conservatorship proceedings if you are incapacitated because you have a trustee. And with a trustee in place, you don't have to go ahead and worry about who should, outside your family system, take financial control of your life in order to make sure that your mortgage is paid, your car note is paid, your utility bills are paid, your medical bills are paid, and so forth. And remember, the conservatorship is one step removed from guardianship of the estate, guardianship of the person. It's something that is put in place possibly on a permanent basis, more often on a temporary basis, assuming recovery from whatever has caused an individual to become incapacitated. If you have a trust, then you have a trustee, and that person fulfills that role, along with, and it could be the same person, whoever's designated as your durable POA. It does not protect your assets from Medicaid or other creditors. So if you are looking, and we'll talk about this in the last of our 4 sessions under paying for aging, to see if you qualify for Medicaid. Medicaid has a look back period that goes back several years to determine whether or not you meet not just the medical, but also the financial constraints required in order for Medicaid as a safety net to kick in on your behalf. Now, a living trust requires a transfer of assets into the trust, which is a simple way of saying you can't just have a paper tiger. It needs to be something that you are operating in good faith with your assets attached to it, and not just a way to protect your privacy in name only. Use it. It's a useful legal device that allows you full access, and those who you trust full access in case you lack the ability to do so for a time or permanently. Now, ultimately, if you've got almost everything you own, or let's just say for the sake of argument, everything you own contained within the umbrella of a revocable living trust, you still need to have what's called a pour over will, because there are going to be some assets that just aren't going to squeeze in there. But a pour over will, which is a legal will, is what, as you might imagine, really just a shell of what you might create otherwise without a trust being in place. Talk to an estate attorney about which works best for you and whether or not it is representative of your family's interests and values. Now, I've mentioned the other documents that I believe everyone needs. The durable power of attorney, formerly known as statutory durable power of attorney for business issues. A notary is required for this. If you become incapacitated, you're not going to be able to put a durable POA in place. So the best time to do this is before an emergency happens. Statutory medical power of attorney with a HIPAA release, HIPAA, otherwise known as the Health Insurance Portability and Accountability Act. And just to make sure that for those grammarians in the room, virtually or in person, are appeased, it is in fact spelled HIPAA. If you ever see someone spell it HIPPA, you have something one letter away from a hippo. It is not a legal document or representative of legislation that was passed in the 1990s. You need this HIPAA release when you create a medical POA, a medical power of attorney, because ultimately you're going to need to have medical information released to you so that you can make best decisions based on your understanding of a loved one's wishes, should they become incapacitated, and whether they face a chronic condition or potentially a life-limiting condition. This is a document where in Texas, you can either have 2 qualified adult witnesses or a notary witnessing your signature that make this document legal and enforceable. Again, the time to do this is before a crisis occurs, because once a crisis has occurred, if you are determined to lack capacity, testamentary, and otherwise, you can't fill this out. And at that point, the decision order is spouse first, then adult children, not one of them with the others going along. They all have a legal say in what happens if you don't have a spouse to make decisions, if you don't have adult children to make decisions. Parents, again, they've got to agree. Then after that, siblings, they've got to agree. Other relatives, they've got to agree. This is probably as good a time as any to go ahead and point out that if you are dealing with this kind of situation in a hospital setting, this is a great opportunity to engage that hospital's bioethics process, which usually involves getting together a subsection of or the entire bioethics committee for that hospital if there are questions and concerns, and especially lack of agreement if you face decision-making by a group rather than by an individual. In the community, the part of HHCI CARES that deals with ethics includes our hosting here what is known as CHECS, the Community Healthcare Ethics Consultation Service. It is unique to our, well, not just to our county, but to our state and our region of the country. I can't and won't predict whether or not this is unique nationally, but I do know that using the same type of professionals, clinical professionals, spiritual care professionals, legal professionals, to go ahead and to help those who request our services consider the various ethical issues involved in a decision for which there seems to be a dispute. We are not mediators. Hospital bioethics committees are not mediators, although we may very well utilize some skills of mediation in order to help people communicate openly and honestly with one another. And we are not binding, neither in hospitals or in the community. In the end, what we're hoping to do is to help you sort through whatever legal, medical, emotional, psychosocial, spiritual concerns are raised when it comes to providing someone who cannot speak for themselves with the best possible care as we perceive their wishes for care to be. And that is why ultimately, besides other advanced directives, a great example of something you can draw up, a living will, which is also a directive to physicians, explaining your wishes for end-of-life issues. 2 qualified witnesses or signature with a notary are what make that legal in Texas, but far more important than what makes it legal is the influence it has over people who are struggling with their own values while trying to champion your values when it comes to aggressive versus comfort care, depending on the situation you face. So, how do I do all of this? Well, if you're starting from scratch, we want to make sure to give you some basic resources to begin with. It's important to note that HHCI generally will only make blanket recommendations to other nonprofit or not-for-profit individuals, agencies, programs, etc. Having said that, we have developed through HHCI CARES a living document. It doesn't have a fancy name. It's simply called our CARES Resources Guide. And it is there to go ahead and to provide you not just with public sector, not-for-profit, nonprofit recommendations on a variety of subjects, but it is also there to give you the names of practitioners, legal, medical, and otherwise, who we have come to know and trust. Should something happen and they no longer command our trust, we'll take them off our list. But unless or until that happens, we do our best to make sure that you are aware of people who we believe speak the language we have been describing in terms of how to facilitate important processes today, such as legal decision-making. So that's why on the really beyond the top 3 bullet points, you see private practitioners listed here. We're not endorsing the entire firm. What we're doing is we're letting you know that these practitioners of these firms have demonstrated consistency in their ability to ethically provide services to individuals who are either just dealing with general questions or are prepared to execute all of the types of legal devices and more that we've introduced today. For your own general education, the first 3 bullet points are quite useful. The University of Houston is one of the law centers here in the Houston area. You could certainly look at South Texas College of Law if you wish to. You could also look at Thurgood Marshall School of Law if you wish to at Texas Southern University. But U of H has a law center clinic that we want to highlight, something unique in our community. And we encourage you to go to their website and to see what they offer. If you happen to find that the other law schools in town offer clinics that you think would be useful for us to add, by all means, let us know. Our email information is going to be on the last slide of this deck. But we also encourage you to look at both the Elder Law Services section for the Houston Bar Association so that you can get recommendations for people, whether you are able to pay retainers and fees, whether you are looking for someone to provide pro bono services. They are a great place to start in your journey of finding a family and estates attorney, whatever works best for you based on the circumstances we're describing. And through the website, and it's an amazing resource, texaslawhelp.org. You'll happen to find the Houston Bar Association's Elder Law Handbook. It is one of many terrific resources on elder law and family law and estates law and more that you will find on that website. And we encourage you to take full advantage of the resources that are there. Yes, private law firms very often offer similar advice, and it's good advice, but this is a true cornucopia of legal resources, and we encourage you to make full use of it. As I mentioned, in addition to educational programs, we're also here to facilitate caregiver support groups, grief support groups, and to provide individual consultations. So our contact information is on the screen. Both Dr. Dettermeyer and I are, in addition to our role here at HHCI, we both share a common background of having served as chaplains. Dr. Dettermeyer in a hospital setting. I have served in both a hospital and a hospice setting. Both of us are theologians. I'm ordained clergy. She has her MDiv. Her PhD is in bioethics, which of course makes Dr. Dettermeyer our point person for managing checks and also community bioethics education. When we get into our next sessions on living options and paying for aging, the other part of my skill set, which prior to coming to HHCI, I served as on staff, first as a volunteer and then on staff at Harris County's long-term care ombudsman program, which along with our county's area agency on aging and Aging and Disability Resource Center, which in Harris County is known as Care Connection. Every county and territory in the United States has these 3 agencies paid for by your tax dollars and therefore accessible to you at any time. In some cases, to go ahead and to answer questions like those that we're addressing throughout the Aging with Grace series. And we can consult you on how to make best use of those resources and the types of questions you want to ask. Also, we can help you if you are looking to navigate your way through care plan or discharge meetings, whether we're talking about hospital settings, inpatient rehab facilities, post-acute care settings, long-term care settings. We're here to help. And what we don't know directly, we have developed a network of referrals for you to take with you and hopefully make good use of as well. So, thus endeth the formal presentation. I'm going to go ahead and stop sharing. And we've got a few minutes if anyone has any questions that they would like to introduce through the method of your choice. Again, a reminder to you that anything that you've registered for through hhci.org/events, which it will include going ahead and registering for our third and our fourth sessions that are coming up next Monday and the Monday thereafter, will mean that you automatically receive a copy of the recording and the slides. If you didn't get a chance to register for a previous event, as Beverly asked at the very beginning, ultimately go to our website, go under the resources tab, and after this series is complete, you'll get the most recent recordings of the series. But we do maintain a couple of seasons worth of Aging with Grace on the website, because sometimes you just need information right away, and we want to make sure that you have it on demand. Now we'll rotate the oldest sections out as the newest sections are recorded and placed on the site, but we always want to make sure that something is accessible to you at any given time. So, for example, if the healthcare rights and responsibilities section is something you need right now, if you go to the resources tab, you'll see last fall's presentation, which probably isn't going to deviate too much, with the exception of any timely adjustments in numbers based on government accounting. So that's something to keep in mind just in case. So Donna asks, if my parents already have durable power of attorney and medical power of attorney, how do I know it has a HIPAA release? Is this a separate form? The answer to that question, Donna, is it should be on that form, and the HIPAA release is there just in case you've got a format that doesn't include it. Odds are, though, if you are being spoken to by the people caring for your loved ones, and Donna, I happen to know you are doing incredible work as a caregiver for your parents. They likely have already taken care of having that release form placed in the various charts for your parents when it's needed, either upon admission, whether we're talking about hospital admission or whether we're talking about admission, whether in this case, I'm going to put it in more general terms, not just focusing on your parents, Donna, but for anyone, hospital admission, as well as admission into a post-acute facility, a long-term care facility, is going to include some type of HIPAA release as well, because your personal health information, or PHI, you get to decide, or the person who is your representative by holding a medical power of attorney gets to decide who is entitled to view your medical information. For that matter, who's entitled to know that you are in a hospital or another facility receiving medical care, period. So that's something that I don't want folks to fret about. It's something you can always go ahead and put together and create in an attorney's office. But if you are in a setting where you are rushing to the hospital and upon admission, the HIPAA release is going to be in there as well. Every healthcare facility has to have it on file somewhere so that they understand who is entitled to the personal health information, your private health information. PHI is something which HIPAA requires the healthcare facilities to protect at all costs. So ultimately, Donna, what I would recommend is that you go ahead and speak to either Peggy or I offline about any specific issues and concerns that you may have. And we are certainly available for you for continued individual consultation. And we're glad you're here today. Anyone else? Please.
So my husband and I have a will that was created by my husband's brother, but out of state, in the state of Indiana. filed appropriately, legally, is there any impact to having your will out of state when you live in the state of Texas? Because I know sometimes Texas can have some laws that maybe other states don't have.
The general answer to that is you're covered and I discussed this in the previous session on healthcare rights and responsibilities, where there's federal law that goes ahead and recognizes a person's right to have, for example, advance directives. And so where advance directives by federal law, states are obliged to go ahead and to honor those, except if a provision in those advance directives is currently illegal under that state's law. And we used as an example of that physician-assisted suicide or medical assistance in dying, which is legal in a handful of states under very specific circumstances and not legal in the others. So what I would say is that if there are legal provisions that the state of Indiana honors, but you're uncertain that the state of Texas does, now's the time to go ahead and to see if you need a codicil to your will. You don't necessarily need to recreate the entire will, but you will want to see if a codicil or some other type of addendum is needed in order to go ahead and to make sure it's fully compliant with what Texas allows, and not knowing, for example, and it shouldn't matter because the four walls of the will are what define the distribution process, along with any other directives, financial and medical documentation that you have in mind, such as powers of attorney and so forth. But we want to make sure if Indiana is not the type of community property state that Texas is, that you're transferring over your wishes as effectively as possible into Texas. So that's where you want to consult with your attorney to make sure that there's no potential unintentional, certainly glitches that relocation may create. Yeah. So Donna, ultimately, I will need to schedule a separate meeting with you. Please email me and I will be more than happy to go ahead and to do so, or email Peggy and she will be more than happy to do so. I'm going to go ahead and I'm going to take us offline. Thank everyone for attending today's session and encourage you to, again, join us for sessions 3 and 4, which one more time are going to be Understanding Living Options, session 3, next Monday. And the Monday after that, our 4th and final session, will be Paying for Aging. I hope you all have an incredible week. I love doing these on Mondays. It's a great way to get the blood flowing because even though I act like an extrovert, I'm not. So it's one of those that I come to with a degree of excitement and nervousness all mixed together. And I find I don't need coffee on Monday mornings. So may your day be energized, gentle, fruitful, and have a wonderful week. You all take care.